car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome. So glad to have you. You are watching The Attorneys. I'm Art Franklin. Our topic today is debt collection and also bankruptcy. As always, we begin the show by making sure that attorneys are standing by right now at Hollis Wright to answer your call. All you have to do is call 1-844-LAW-TALK. That's 1-844-LAW-TALK, and that's where you can get information about all the things that's taking place. And we're talking about debt collection, and as we talk over here to my buddy here, Carter Clay.
Art Franklin, good to see you.
Good to see you, buddy.
Yeah, some sobering statistics to kind of highlight the importance of this topic. In 1999, at the end of the year, there was about $500 billion worth of credit card debt out there. Wow. Now, fast forward to the end of 2024, there's over $5 trillion in credit card debt out there. So you can imagine the overwhelming sense that a lot of people out there have that are dealing with not only just credit card debt, but payments on mortgages and medical bills and all of the other things, and bill payments at their house, electric bills. All of those things can pile up and add up and become very stressful and overwhelming for individuals out there, and ultimately lead them to have to make the unfortunate decision on whether or not they're going to default on all this stuff, or are they going to be able to pay it, or alternatively, should they file bankruptcy? And we've got Gina McDonald here with us here this evening to talk about this and unpack this subject. Thank you so much for being here.
Thank you for having me.
Tell us a little bit about your legal practice and how you got involved in this area.
You know, I was in law school and I had a family member that went through a bankruptcy and had a terrible time with her lawyer and how she was treated. She felt demoralized and embarrassed, and I decided I'm just going to, when I graduate, I'm going to do bankruptcy law. I already had a background in business, so it made sense, in finance. So I interned with a bankruptcy attorney, and then after I passed the bar, I started my own firm, and that was in 2004. And I've been going strong ever since. I have offices in Jasper, Aniana, and Pelham, Hoover area.
Wow, so for 20 years, you've been helping individuals through the whole bankruptcy process.
Yes.
Let me ask you, because this is something that kind of jumps out at me, and I want the viewers to kind of understand this, is what should they be thinking about if they've got a mountain of debt and they're not able to pay it? Like, how do you know when it's time to consult with somebody like you about the possibility of bankruptcy as opposed to going in an alternative direction, or just, I guess, continue to tread water, so to speak?
Right, and that is the hardest thing, because the hardest call to make is to the bankruptcy attorney, and I recognize that. I think when you get to the point where you can't keep your water bill paid, your light bill paid, you're behind on your mortgage, you know that you're living paycheck to paycheck, and you've done everything. You've called the credit card companies and asked for 0% interest. You've got on payment plans with lenders. You've modified your mortgage. When you've done all those things, it's time to call some professional, specifically a bankruptcy attorney, and get help.
Yeah. Because
we know how to help you. And it might not be bankruptcy. It may be that I just negotiate a credit card debt where someone has sued you. It may be you're behind on your mortgage and we've got to stop a foreclosure. But you need to call somebody and get professional help. If you had an ailment, you'd go to a doctor. And that's kind of how I see that. I see my waiting room as a triage, and they come see me and we try to fix their problems as best we can.
Now, trying to think like a viewer who's facing significant debt, I'm sure that their thought process is, well, I can't even pay the debt that I currently have. How in the world can I afford to hire an attorney to help me potentially file bankruptcy? How does that work in terms of you getting paid?
Right. I get that question almost every day of the week. When people find out I'm a bankruptcy attorney, they're like, how do you get paid? How do you make money?
Because I imagine when they come to you, they're like, I got all this debt, I can't afford to pay you, right?
Exactly. In Chapter 7, our fees are due up front and they're payable. payable because I cannot be a creditor in my own client's case. So therefore, people have to resort to family, friends. Sometimes they just don't pay their credit card bills for the next month and they have enough money to pay me. Hopefully they've held off the creditors long enough. In a Chapter 13, the majority of our attorney fees are in the Chapter 13 plan. Chapter 13 is a debtor's court and you pay it back over 3 to 5 years. So most of our fees are in that plan. So you really don't have to have a lot of money to start a 13 because we charge very nominal fees up front in a 13. But a 7, you got to pay me before I'll start the work.
All right, and let's talk about Chapter 7 for a minute, because I think once we talk about Chapter 7, people will start to realize that it's not that big of a deal to have to pay you up front. So explain what a Chapter 7 bankruptcy is.
Chapter 7 is historically called a liquidation bankruptcy. What that basically means is when a client comes to me, they're allowed to have so much equity in their home, $18,600 per $800 per debtor, so much personal property, about $9,400 per debtor. We protect those from creditors. So if there is nothing to liquidate, there is no liquidation. It's a simple bankruptcy. It's 90 days, start to finish. Chapter 7, you can keep your house if you don't have too much equity in it and you're current on it. You can keep your cars. That process is called reaffirmation. We tell that creditor, we want to keep our car, we want to keep paying for it, we want to keep our house, we want to keep paying for it. But that mountain of credit card debt or medical bills or lawsuits that have piled up against you, we can make those go away. It's relatively easy to do as long as you meet certain things. You haven't filed in the last 8 years to Chapter 7. You're underneath what we call the median income. The government, IRS, sets a standard for every county in the country for what the median income for is a household of 2, a household of 3. If you're underneath that, and if you don't have the means to pay the debt, then we obviously can put you in a Chapter 7 and make that debt go away. It's discharged after 90 days. You have one court appearance, which isn't even an appearance any longer. It's a telephone call. COVID, everyone decided to do 341 meetings of the creditors, that one court appearance by telephone now. So most of my clients never see the inside of a courtroom.
Yeah, and so after that 90 days, you get that fresh start, so to speak, financially fresh start that the bankruptcy system is designed to provide.
Right, you get a fresh start. Creditors, you will get credit again. Trust me, I've got a lot of repeat business, unfortunately, but you will get credit again. And typically, most people's credit score goes up by 100 points because your debt-to-income ratios change on your credit report.
Yeah. Now, before we go to break, I do want to talk about the automatic stay.
Yes.
Because I think that is important, because when you're getting paid up front, the automatic stay will help people realize why they can reallocate some of the money that they were paying towards some of these other debts to pay your fee. So talk about what this automatic stay is about.
Okay, the automatic stay it's imposed by the federal government, and it's the protection from the federal government. I explain it to my clients, it's a bubble. When I file your case, when I push that button, you go into a bubble of protection. And you stay in that bubble for the full 90 days, unless a creditor tries to pop it. For example, if you're behind on a mortgage, they may file a motion for relief because you've been so far behind on the house and you're giving it up anyway. A creditor would have to file that with the court to get permission to even attempt to contact that client. Otherwise, the automatic stay means a creditor cannot contact my client. They have to come through me or through the court. It's important because, for example, if I have someone who has a car and they're behind on their car payment, that automatic stay goes into effect and it prevents a creditor from repoing that car. Yeah. So we can reshuffle money during about 60 days or so before the creditor can file a motion with the court to have the bubble burst, and we can direct that money towards the attorney fees. Another way that people, a lot of times I have people, they're not behind on any of their credit card debt. They're paying $2,000 a month on credit card debt. I'm like, are you kidding me? You know, if I push this button, then you don't have to worry about paying this credit card debt. Don't pay the next month's payment. Let's get this case filed.
Yeah, and of course there's a ripple effect, Art, to all of this, which is if your car gets repossessed, now you don't have transportation to get to the job that you need to have to earn the income to start to pay off all of these debts. So it really is beneficial, at the very least, to call a bankruptcy attorney, get some advice from them about whether or not they are a good candidate for the bankruptcy. Now, up to this point, we've talked about the Chapter 7, which is total liquidation, sell the assets that you have, get that fresh start. When we come back from the break, we're going to talk talk about Chapter 13 bankruptcy, which the viewers need to know about as well.
All right, we're going to go ahead and take a break right now. I want to remind you, though, that you can still reach an attorney at Hollis, Wright. They start manning the phones the moment the show goes on until the show is over with. All you have to do is call 1-844-LAW-TALK. That's 1-844-LAW-TALK. You get a free call, and it's confidential as well, as we're talking about debt collection and bankruptcy for this edition of The Attorneys. We'll take a break, and we'll be back after this.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery. Find community.
at Bradford.
Welcome back. You are watching The Attorneys, and throughout the show, you'll notice at the bottom of your screen, we are scrolling information about the topic that we're discussing. There's also a QR code on the screen. You can scan that as well. Just another way that you can get in contact with someone at Hollis Wright. By the way, they're taking your calls right now. 1-844-LAW-TALK. That's 1-844-LAW-TALK for a free confidential call. We're with Gina, and we're talking about bankruptcy.
Yeah, absolutely. We talked about Chapter 7, which is total liquidation. I want to talk now about Chapter 13, but I also want to talk just sort of 30,000-foot view. I think it's important for the viewers to understand that when we're talking about Chapter 7 and we're talking about Chapter 13, what we're referring to is federal bankruptcy law. Obviously, we've got federal statutory law and we've got state statutory law here in Alabama, but the bankruptcy code that we're talking about is derived from federal law that has been passed many years ago.
Correct.
And been amended,
and
correct?
Been amended, yes,
okay.
Correct, yes, sir.
All right, now with respect to Chapter 13, as I understand it, and I want you to put some meat on the bone here, so to speak, but as I understand it, Chapter 13 is a bankruptcy process that people can avail themselves of that will allow them to continue to pay on the debt that they have, but it basically restructures or modifies the payment schedule to be consistent with what the person can afford.
In a nutshell, yes, that's it. There's variations of a 13, but basically 13 is intended for someone who makes too much money and doesn't qualify for a 7. someone that's tragically behind on their home, but they want to keep it, so I've got to put what they're behind on their home into a 13 and reallocate that money. They're behind on a car, and a 7 would result in probably a repo if they can't get it current. So those are the people that go into a Chapter 13. People who filed bankruptcy Chapter 7 before typically can't file another 7. They go into a 13 if they get in trouble again. A lot of the Chapter 13s right now, believe it or not, are being driven by credit card debt, which has been a shift. You know, before it was because they were behind on a car, they were behind on a mortgage, but now, and also because there's so much equity in people's homes, they can't necessarily file a 7. So 13s are being pushed by credit card debt. When the prime interest rates went up, people's credit card interest rates went up, so their minimum payments went up. So people come to me and they're like, my payment went up $200 for each credit card. I can't pay this. It doesn't fit in my monthly budget. Those are the people that I'm helping in Chapter 13. What we do is put all the debt that you have, the unsecured debt, into a plan. Your secured debt, such as your car, would go into the plan too. If you have arrearages on a mortgage, it would go in. Tax debt goes in. We just reorganize that, reshuffle it, and we set up a fixed payment that you pay every month for 60 months, for up to 60 months. And there are variations of Chapter 13. I don't want to get too detailed, but there are some people that I meet with that don't have enough money to pay 100 pennies on the dollar to that unsecured creditor. So we do like percentage cases where they pay the good stuff in full, but their unsecured debt may get 50 cents on the dollar or 80 cents on the dollar. So those options are available for people too. So you can still, typically when I sit down and look at someone and I look at their minimum payments they're paying now, when I put them in a 13, and you've got to remember, those debts are not going to be paid off for 20 or 25 years if they're paying the minimum. But if I put them in a 13, in 5 years, those debts are going to be gone. There's no interest on the credit cards in a Chapter 13. So you're only making the balances get smaller.
And I'm sure there are individuals out there that don't want to go through liquidation. They don't want to give up the car or house or the items that are not exempt from liquidation. These are things that they've had, their possessions that they've had for years.
Exactly, and that's what we're seeing. You know, when the price of homes went up so drastically over a year ago, so many people have so much more equity in their house than they had 2 years ago. Those people may have been eligible for a 7 2 years ago. They're still eligible today, but now they have an asset that's worth more than the law allows them to have, and if they file a 7, that asset could be liquidated. So they need to do a 13 to protect that asset and then to keep people from filing lawsuits and judgments against that asset as well.
Now, I know this is a question that comes up, and I know you see this from time to time, but what happens if somebody initiates the Chapter 13 process, they get their debt restructured, and then at some point during the process, they fail to live up to the obligations of the payment through the Chapter 13 bankruptcy? What happens then?
If they completely fail, the bankruptcy, I call a Chapter 13 like a river. It's like ebbs and flows. The bankruptcy court will give you a chance. If you miss a couple of payments, we can sometimes file a motion to suspend payments. We can file a motion to modify a payment. There's lots of tools that we have. And if they just they can be put on probation for 12 months as long as they make their payment for 12 months. But if it gets to a point where everything has been exhausted, the case will be dismissed. Sometimes those people there may have been something that has changed in their life. The value of their home may have gone down, their income may have gone down. They may be eligible to convert to a Chapter 7 then. So those are options as well.
But there is an opportunity perhaps during the process, if need be, to modify or amend the structure of the plan that then comports to their present or current income situation or ability to pay.
Yes, in most instances, but not in every instance. It just depends on how much money someone makes and what their assets are.
Art, I know you've got a question.
No. I'm just sitting here just enjoying the interesting conversation here about that, but I'm wondering if there are common mistakes that people make when they've got to face a bankruptcy.
Yes, there are very common mistakes, and I see them often. One is they know that they're up against it, and they own let's say they own 10 acres in Fayette County, and it's in their name, it's worth $100,000. They know they're facing a Chapter 7. They transfer it to their son. That's a transaction that can be undone by the Chapter 7 trustee. It's an insider transaction. Bankruptcy law allows a trustee, who is the person that kind of sets into a Chapter 7 and says, okay, you've got assets or you don't have assets, kind of runs the case. And if he looks at that transfer, which we have to report, every petition is signed under penalty of perjury, if he looks at that asset and realizes it was transferred to an insider in the last year, he's going to undo it, and that insider is going to lose that asset, and that money will be used to pay creditors. That's one thing. You don't need to run your credit card bills up. You're limited to luxury items in 90 days prior, up to $800. 70 days prior to a bankruptcy, you're allowed to do up to $1,100 in balance transfers. So those are things, don't go to Disney World 90 days before you're going to file a Chapter 7, because more than likely you're going to have to pay that money back. You can pay it back. The creditor will allow you to pay that portion that you charged in those 90 days back. But that is a common mistake, is that people run their credit cards up.
And one thing that I want to add to that we see in our practices that a lot of our clients are surprised about is the lawsuits that we handle for people where they're injured in accidents. Well, guess what? That is considered to be an asset of the bankruptcy estate. And so if we've got a client and their case goes on for 2 or 3 years, and unbeknownst to me, they go out and they file a Chapter 7 type bankruptcy, total liquidation, they get discharged, and they don't disclose to the bankruptcy court that they have this lawsuit that they're pursuing with us, and they're discharged, and the opposing party in our case finds out about it, it can wipe their lawsuit out, because the bankruptcy court kind of considers that to be a fraud on the bankruptcy court, that you failed to disclose an asset that you had, so you were discharged basically under false pretenses, et cetera. So the communication has to be there between the attorneys at our firm handling personal injury cases and a bankruptcy attorney.
Which is why we say on this show all the time the importance of having representation, to have a law firm, whether it's Hollis, Wright, or another, but it's important to have good representation too, that's going to give you the proper information that you need.
That's right, and we work closely with Gina and other firms as well all the time on these types of matters.
That's right. Well, we're going to take another break. We're going to take that break now, and we're going to continue to unpack this as we get into our last segment on this show. But I want to remind you, you've got your last opportunity to reach an attorney at Hollis Wright right now. Call 1-844-LAW-TALK, 1-844-LAW-TALK for that free confidential call with one of the attorneys at Hollis Wright. We'll take a break. We'll continue right after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
Welcome back. You are watching The Attorneys. Glad you stayed with us as we are talking bankruptcy with Gina McDonald. And I know we don't have a lot of time left, but we still got a few things we want to unpack.
Yeah, and I know people are out there wondering or thinking, I don't want to file bankruptcy because I'm concerned about what that will do to my credit, what my credit report will look like, and will I ever get credit again? Will I ever be able to buy a car again or buy a house? What advice would you have to people who are thinking along those lines?
If you're thinking along those lines and you're filing a Chapter 7, I tell people all the time, there is life after Chapter 7. You'll probably get a car offer while you're actually in the 90 days of a 7. You'll probably get credit card offers during that time. When the bankruptcy code changed in 2005, it put 8 years between bankruptcies, Chapter 7s. It used to be 6. We had all kinds of fancy ways to avoid people. We could put them in a 13 if they got behind on debt. But when that changed, when that 8 years changed, it made creditors more willing to give credit to someone that's just coming out of a 7, because 8 years is a long time, and if you can't make those payments in 8 years, they're going to get you. And
so
you
when
can't
you say
file
8 years, you know about before you could file bankruptcy
before you can file again, right?
Okay.
And so as soon as I file that bankruptcy, I tell clients, you're a better risk tomorrow than you are today, because they you can't file for 8 years. And so creditors are much more friendly now to debtors who need to get car loans. I've had people get home loans. You know, FHA guidelines say 2 years from the date of a filing of a discharge of a Chapter 7 bankruptcy, you can't be discriminated against just because you filed a bankruptcy as long as your credit score has come back. And for the most part, most credit scores come back. We have a tool we use that can show what your credit score will look like 12 months.
Yeah.
You got to remember, all that debt you had's gone. And let's say you've kept your car and you've reaffirmed it, or you're paying your student loan debt. Those are reporting to your credit, so it's building your credit back up.
Yeah.
So there is life after Chapter 7. Chapter 13 is a little bit different. You're not supposed to incur any new debt while you're in a 13. So without the permission of the court.
Right.
So that's a little bit different, but typically after a Chapter 7, 2 years after that, your credit will start rebuilding.
How long does a bankruptcy filing stay on somebody's credit report? I mean, I guess it goes on the credit report. How long does it stay on?
A Chapter 7 stays on for 10 years, and I encourage clients that if the 10-year mark comes and it's not been removed from your credit bureau, contact those credit bureau agencies and have it removed. A Chapter 13 stays on your credit report from file date 7 years. So if you finish in 5, 2 years more, it's on your credit report, then it drops off. And once again, I encourage people to reach out and make sure it drops off.
Yeah. How does the bankruptcy code work with respect to married couples in terms of whether husband goes out and takes a credit card out but wife's not on it, or vice versa? Do they both have to file bankruptcy? Is one not subject to debt collection? How does that work?
If the credit card is only in the man's name, let's say all the debt's in the man's name, he can file a Chapter 7 bankruptcy and the wife's not included. Now, if she works, her income is included in doing that means test for a Chapter 7 or looking at a Chapter 13 payment. We take into account her expenses, but her Social Security number is not on the petition, her name's not on the petition, she's not affected at all. Married couples file often. Sometimes I have a married couple that the man will file a 7 and the wife will file a 13 because they have different situations.
But I guess your advice would be, don't try and transfer your assets from the non-signing spouse to the other one, because like you said earlier, that can be reversed and undone and those assets can be brought back into the bankruptcy estate.
It's a big red flag.
Yeah. Yeah.
And certainly if you do that, tell your attorney, because we need to know those things to protect you and to give you the advice that you need. I mean, it might be that you wait a few years before you actually file a bankruptcy. Maybe we can do other things to hold off a bankruptcy if you've done some sort of transfer like that.
Yeah. Closing in on the end of the show, but we've got enough time to talk about these debt counselors that are out there. Are you familiar with those companies that are out there, and kind of what are your thoughts in regards?
I have to be really careful how I talk about those people, but I will say this. I'm sure there's good agencies out there. There are some, though, that you pay your money in, and what you're paying in, the contract says the money that you're paying in is earned by that company, and they may not have even negotiated one debt for you. 90% of the time, if I've got somebody that's in a debt repayment program, debt relief agency, they come into my office with a lawsuit. You know, Discover sued me. I'm in a debt relief agency. Well, Discover doesn't have to participate, and that's where the federal government automatic stay comes into effect, and the fact that it is federal law. So if a creditor doesn't file a claim in a Chapter 13, and you pay the case out, they never get paid. But if you're in debt relief, there's no federal protection.
Yeah.
And that's the most critical component of that, is that there's no protection from the federal government.
Real quickly, can a boss fire somebody for filing a bankruptcy?
So I think it's Section 525 of the code says, no, they cannot. You cannot be fired for filing a bankruptcy. Now, they can come up with other ways. Yeah. But I've never heard of anyone filed. No one's ever called me and said, I filed bankruptcy and I got fired.
Gina, thank you so much.
Thank you.
It's been a great show.
Thank
Wealth
you.
of information, Art. I know the viewers really benefited from her knowledge here this evening.
Absolutely. We really do appreciate it. And we really do appreciate you joining us as well. And make sure you go ahead and make a day for next week so you can join the attorneys once again. We'll have another exciting topic, good information that you can use, and follow us on all social media platforms as well. Thanks for watching. We'll see you back here for another episode of The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.